Hey, thanks, Scott. Also, thanks to Tom and the IWRA colleagues for organizing this webinar. I hope everyone can see my slides here. I'm talking about the authority of where the UN Watercourses Convention derives its authority, and so I'm not going to focus entirely on this why entry into force matters. I'm really sort of looking at that history, but that history is very important for then discussing these questions of the value of entry into force. So I think that will become obvious as our discussions come along. Well, it's a long history, the drafting and the negotiation and adoption of the Watercourses Convention. In 1959, it was a UN General Assembly resolution, so all states coming together to call on the Secretary General of the UN to conduct studies on the legal problems relating to the utilization and use of international rivers. And by doing that, asking member states to provide information regarding their laws and legislation, bilateral treaties, decisions of international tribunals, including arbitral awards, and surveys and studies of non-governmental organizations concerning international law. So working out what the existing practice was already out there. That work led to a decision, again by the UN General Assembly, in 1970 to ask the international law, the legal body of the UN expert body responsible for codifying customary international law. Customary international law is seen as unwritten law. So taking that unwritten law and codifying it, putting it on paper within a set of draft articles. Why did states within the General Assembly think that was an important thing to do? Well, the reasons they gave within the resolution in 1970 are I would say highly relevant today, around concerns around population growth, increasing multiplying need, demands, a growing concern of humanity, fresh water availability being limited, need to protect and preserve water, seen as important to all nations, conscious of legal problems, disputes, etc., around transboundary waters, and quite an important point, I think the last one, despite a great number of treaties, bilateral, multilateral, basin-specific, regional treaties, the law was still based in part on general principles and rules of customary international law. So we need to add more clarity to the rules and principles of international water law. Is a key aspect of this exercise. And it was a very extensive exercise. I'm not going to go through all of these bullet points, but this is just to show you that there was a lot of work done by the International Law Commission to firstly understand this existing practice, how some common trends going through these different bilateral basin-specific treaties within different regions of the world. And that's why I titled this slide "Bottom-Up Approach," because this wasn't an exercise where independent experts within the International Law Commission came together and thought, well, from our viewpoint, what would be an ideal set of rules and principles for sharing international watercourses. Rather, it was an exercise in trying to understand what existing treaty practice and other practice, decisions of courts and opinions of experts and so forth, what practice was already out there, and how could that be put into a nice concise set of rules and principles. And then it's also important to recognize that the states played a really strong role first in the drafting of a convention. So the drafting exercise through the work of the International Law Commission, which lasted from that request in 1970 to 1994, when they produced their 94 set of draft articles on the law of non-navigational uses of international watercourses. There were a number of opportunities there for states through questionnaires solicited by the International Law Commission, asking states for their opinion on the direction of that work. That fed into the development of those draft articles, and then the draft articles were presented to the UN General Assembly and formed the basis by which states could then draft the Watercourses Convention. So they took a conscious decision to take those draft articles and negotiate within the 6th Committee of the UN General Assembly in 96 and 97, negotiate a convention on the law of the non-navigational uses of international watercourses. So that process went through. The draft articles were discussed. The ILC draft articles were discussed, article by article. A number of recorded votes were taken on more contentious issues around the texts, around our existing agreements in Article 3, the relationship between equitable and reasonable use and no significant harm, Articles 5 and 7, and dispute settlement, whether that should be compulsory in Article 33. And within within those discussions, which is freely available on the UN website, you can see 54 nations recorded statements on their view on what this convention should look like. What was the outcome of the negotiations? Well, the convention was adopted in 1997. A recorded vote was taken when the convention was adopted. 103 nations voted in favor, 3 subsequently informing the UN General Assembly that they intended to vote in favor, 27 abstentions, and 3 nations voted against: Burundi, China, and Turkey. And there were, again, on adoption, there were a number of statements for and against the convention by various states that I've listed there. So just in a final remark, I wanted to emphasize this persuasive power of the UN Watercourses Convention, and think that the international law generally has, we describe it as a horizontal system. There's no police power that oversees. It requires on reciprocity between states to ensure it's the rules and principles of international law are complied with. And so I think what that means is that it makes that the perception of the legitimacy of international law becomes really important, and then so these processes by which rules and principles are formulated, adopted, and implemented are crucial. And I think what we see with the Watercourses Convention is that it certainly does have this really long history, a deliberate exercise of engaging with states within the General Assembly and through the work of the International Law Commission. That really does give it quite a lot of persuasive power. And just one bit of evidence of that that I put up here is a quote from the International Court of Justice, who when they were deciding the Gabčíkova-Načmoroš case between Hungary and Slovakia, mentioned the convention, and mentioned it in September 1997. So pretty soon after it had been adopted in May 1997, and they described it as providing evidence of customary international law even before it entered into force. And so I think this just attests to the importance and the persuasive power of the convention, and the more we can do to advance that persuasive power, perhaps by more states joining the convention, developing tools and mechanisms to enhance its implementation, to promote it and enhance its implementation, the better. And other presenters will go into a lot more detail on these aspects than me. So I'll leave it there, yeah, I hope that gives a nice overview, at least, of where this convention came from. Thank you.